Our next speaker will be Robert, also known as Tim Coulter. He's a Potawatomi lawyer and activist. You've heard his name already mentioned a time or two. He's an attorney who practices in the fields of Indian law and international human rights. He's a founder and executive director of the Indian Law Resource Center in Helena, Montana, and in Washington, D.C. The center provides legal assistance for indigenous peoples throughout the Americas. He's an enrolled member of the Citizen Potawatomi Nation and a justice of the Supreme Court of the Citizen Potawatomi Nation. Born in Rapid City, South Dakota in 1945, he received his bachelor's degree from Williams College, Williamston, Massachusetts, and went on to get a degree in law cum laude from Columbia. With more than 35 years of legal experience in the field of Indian affairs and human rights, he's published numerous articles on these and other fields of law. Before starting the center in 1978, he was acting executive director of the Institute for the Development of Indian Law, a staff attorney for the Native American Legal Defense and Education Fund of the United States Commission on Civil Rights. He's been awarded the Lawrence A. Wine Prize for Social Responsibility by Columbia University Law School and the Bicentennial Medal by Williams College back in 2002. Earlier this year, Coulter and the Indian Law Resource Center received the prestigious Gruber Foundation International Justice Prize. The center was one of 3 recipients being recognized for significantly advancing human rights under law for victimized groups. Mr. Tim Coulter.
Good morning, and thank you all for coming. I'm very pleased to be here and to see many of you that I have had the pleasure to work with over the years, and some of you I haven't seen in quite some time, so it's a pleasure to be here. You may enjoy the next few moments while I try to make the PowerPoint work. It's sort of part of the entertainment, a kind of a break, I guess. First I have to get rid of Willie's. Escape, thank you. Again, why don't I just exit out of it? See, I told you. I even practiced back there on my laptop, but I didn't practice getting rid of another PowerPoint. See, there's mine. I think if I just hit it twice, it'll work. But now I have to press, I learned this just a few minutes ago, I have to hit this little icon down here and it'll look about right. There we go. See, I did this just for you guys. Actually, what I've done is to try to talk about both things that Professor Rice, a.k.a. Bill, asked me to speak about. By the way, I'm a.k.a. and usually K as Tim. Everybody calls me Tim, so that's me. Call me Tim. Another thing about about this, I don't mind being asked questions at all, and I don't mind being interrupted. I usually didn't have much of a train of thought anyway, and so if something seems obscure or worse, or you have a question, just go ahead and ask. It gives me a break, and it probably will help other people as well as me, maybe help me dig out of whatever mess I got myself into. So go ahead, ask questions when you feel like it. I don't think I should apologize, actually, but I sort of warn you anyway that I'm going to perhaps cover a lot of ground. What I want to do is talk first about why we went to the United Nations, at least from the point of view of people, that is, Indian people in the United States and in Central and South America. We came at it a little differently, somewhat different approach from what Willie described, but that's the way the world is, isn't it? we all get involved in things together and we end up seeing it a little bit different. And all of these views are valid, but I'll be giving you my point of view, at least, and point of view of some others I was working with. But then I want to go on without too much dwelling on the UN Declaration and talk about our more recent effort to incorporate some of the major principles of the UN Declaration into United States law. Because the United States law about Indian nations, about Indian affairs, is awful. And that's one of the main reasons we went to the United Nations to work at the human rights level in the first place. So at about the same time that the United Nations was clearly going to adopt the Declaration, we started working on rewriting, or at least writing concrete proposals for how United States law ought to be changed, or how United States law ought to be clarified. And so I want to move into that and show you what these draft principles are and discuss them with you, because I think that will help perhaps to show how this stuff in Geneva, how this human rights world can be translated into positive action and actual concrete reforms that should improve the lives and welfare of Indian and Alaska Native nations in this country and in others too. Well, let's start. I think if I do that, you'll see the next slide. Why was the UN Declaration started? Well, from my point of view, I was practicing law, trying to work on Indian land rights cases mostly. That wasn't the only kind of case we handled, but we found, everybody found, that United States law about Indians, and particularly about land, is awful. For one thing, Indian rights of Indian peoples, I hate reading off the PowerPoint, so the stuff I say may not be exactly what's up there. You read that, I'll tell you what I'm thinking. I wrote all that, but I'm not going to read that stuff. You can read it. The law that we found, and I argued many a case in the federal courts, was that the rights of Indian nations are, for the most part, simply not protected by the United States Constitution. The federal courts freely and openly decide that Indian nation land that's held by Aboriginal title, and that's the majority of Indian land, is simply not protected by the Constitution. It can be confiscated, taken, controlled, whatever, by the United States government without due process of law and without compensation. That is an exception in the Constitution. It's not an exception in the Constitution, except that the courts decide cases that way. The U.S. Supreme Court has decided that when the United States government steals, confiscates, takes Aboriginal title Indian property or natural resources, it does not have to pay for them, it does not have to abide by due process of law, and it can be for any purpose whatsoever. It doesn't have to be for a public purpose. In other words, the Fifth Amendment doesn't apply to most Indian property. The federal government not only is given that authority by the courts outside the Constitution, but it exercises it. I'm litigating a case on that very point right now in the federal court in Washington, D.C., where Congress enacted a law directing the Secretary of the Interior to simply confiscate a fund of many millions of dollars in the United States Treasury that belongs to a number of Western Shoshone Indian tribes. Simply confiscate it, leave not one dime for the tribes. The Secretary of the Interior is directed to make up a roll, not of the members of these tribes, but to make up a roll of Indians who meet various qualifications set by Congress. So Congress freely steals the money that belongs to the tribes and gives it to others, to individuals. That's absolutely contrary to the so-called government-to-government relationship. But the key thing is that Congress understands and believes and acts on the principle that it can freely confiscate money, land, resources, or anything that belongs to an Indian nation without paying for it, for any reason it wants. doesn't have to abide by any legal rules or restraints. And that, it's not just something that they manage to get away with. The Supreme Court has said they can do that. It's absurd. The United States government claims the authority to simply terminate Indian tribes or Alaska Native tribes, do away with them altogether as a legal matter. Of course, they can't actually destroy a culture except by, well, they can as a practical matter, but they can and do and have terminated many tribes. There's nothing in the Constitution that gives Congress authority like that. They can't terminate anything else. They can't terminate a Mother's Day tea, except they can terminate Indian tribes, can't they? They can also make contracts with Indian nations, called treaties, and violate them at will, usually with no liability whatsoever. Sometimes there's liability, sometimes something can be done about it, but for the most part, and in the usual case, nothing can be done about it. I don't think the federal government can make a contract with anybody else other than an Indian nation and violate it at will without liability. We could go on, if I don't get me started. The Plenary Power Doctrine you may have heard of if you've studied federal Indian law. That is a doctrine of law, so-called anyway, that comprehends many of the things I've been talking about, that simply proposes or states that the United States Congress and the federal government in general has practically unlimited authority to do anything it wants to Indian and Alaska Native nations and their resources and other property without any restraint in the United States Constitution. There's no such doctrine that applies to anyone else in the United States, except there are some provisions that purport to give the United States some plenary authority over immigration. But so far as others who live within the United States, there is no parallel example. In other words, Indian nations are deprived of fundamental constitutional rights that everyone else enjoys, even non-citizens. Well, we could not well imagine prosecuting land rights cases. In fact, I was involved in one of the early Trade and Intercourse Act cases, the land claims that were filed in the federal courts based on the Federal Trade and Intercourse Act that made it unlawful to purchase or acquire Indian land without the approval of the federal government. It made all such transactions void, ab initio, void on their face, invalid. But when we spoke to the Interior Department about the Oneida Nation claim, the solicitor of the Department of the Interior, a lawyer named Leo Krulitz, and he's the top lawyer for the Interior Department. He told us to our face, and we actually have a tape recording of it, that unless the Oneida Nation got busy and made some proposals for settling this claim, the United States government would go to Congress and seek and get legislation that would simply extinguish that claim with no compensation. He knew absolutely that the Supreme Court approves of that kind of thing. Now, the United States government can't do that to anyone else in the United States, but they can and do it to Indian nations. It hasn't changed. That happened back in the early 80s, but it hasn't changed today. The law is just the same. When I discussed that with Indian nations I was representing, they agreed that we needed to try to do something that would get the attention of courts, get the attention of government officials, that would get us above this level of federal courts that were simply not listening to us. I would argue in the Court of Appeals in Washington, D.C., and, well, what legal authority do you stand on? Well, these three judges up here, and I say, well, the Fifth Amendment to the Constitution says the government can't do this. Yes, but I mean, are there any precedents, any cases you can cite? Even the law review article? Well, no, there weren't any. And I lost repeatedly. It was perfectly clear that the courts were going to enforce this absolute inequality under the law. You know, the Supreme Court building has that great phrase up there, equal justice under law, but it's not true for Indian nations. And we learned that painfully over and over again in the early years. Well, I learned it after I got out of law school. Other Indian leaders had known that for generations. You know, Indian nations couldn't even file claims in the federal courts until, when was it, Professor Robertson? Yeah, didn't even have access to the courts until the early 70s to file claims like that. Well, little wonder then that there was some need to try to appeal to some higher authority to build a foundation for changing this kind of, in my opinion, oppressive and discriminatory legal framework. I'm taking too long. I'm going to have to speed up, but that's, from my point of view and from the point of view of the Six Nations and some of the traditional Seminole people and Hopi traditional leaders and others that I was representing at the time, that's why we went to the United Nations to try to see what we could do to change this business. A guy can get all wound up making a speech like this, you know, and you got to back off a little bit. But actually, there's a serious side to it, and that was that, you know, one reason that this kind of really perverse law survives in the United States is because of that sense on the part of the society in general that, well, it's only temporary. You know, yeah, it's unfair, but in another generation, they won't even be here. So really, it doesn't matter very much. There has been this presumption that we either are extinct or will be. That's another icon. Isn't that in Oklahoma City or Tulsa? I believe it's Oklahoma City, isn't it? That image expresses the, let's say, the American view that Indians have had it, you know. The lance is down, the horses wore out, it's the end of the trail. I believe that's the name of the sculpture. And so you don't really have to have permanent rights for people who are about to go out of existence. All right, the laws are unfair, but it won't matter. But of course, it does matter. We didn't go out of existence. Lots, look at you. The other thing about these horrible laws is that it makes for terrible conditions in Indian country. It makes it extremely hard to have any kind of serious economic development. It's hard to govern. It's hard to do anything in a normal way when you don't have a reasonable, just, and fixed legal framework that can be relied on. Who wants to invest in a system like that? Who wants to try to operate a business in a business climate like that? It's absurd. And so people don't, except for get-rich-quick stuff. You know, rip off the Indians or, you know, have casinos. I think we're going to have houses of prostitution next because that makes a lot of money. So we wanted to do something different and decided to go to the UN. Of course, everybody said we couldn't do it. Everybody said it was foolish, it's unpatriotic, and even those that were on our side generally said, oh, but for heaven's sake, don't demand self-determination. That's a dead loser. You wouldn't even bring it up, they said. I've always enjoyed that little cartoon, so I thought I'd stick it in. See, our general idea was we ought to have pictures and not very big words, but I'm afraid I've got a total lot of words coming up, so let's keep moving. That's what it looked like in 1977. Those there in that row are primarily chiefs of the Haudenosaunee or Six Nations Confederacy. That's just my own, these personal snapshots, really. About 100 delegates were there of Indian people from the United States, Canada, Central and South America, and lots of people from Europe and various countries. That's Tadadaho, or Leon Shenandoah, the Tadadaho of the Confederacy on the right, and a Oneida chief with him. That was same day, same time, September 1977, at that first conference where we introduced the first version of the Declaration. Something tells me I skipped a slide. Yes, there's some more slides. Contrasting the 1977 lineup of some of the people with the way it looked toward the end of the working group process in Geneva. I think that was taken in 2006 at one of the last working group sessions. That's the Navajo Nation delegation there, and down at the end, that white-haired guy is Tizai, I'm afraid. That's what the working group looked like from behind the podium. We usually filled up the room. There were thousands of people that attended and worked in these sessions. Thousands not at any one time, but over the years, at any given meeting, there was anywhere from 100 to 200, 300. Some of the working group sessions had as many as 800 or 900 people, indigenous people present. Enormous level. That's the General Assembly, big deal. It wasn't even the day it was adopted, it's just a picture. Moving on. A little summary about the Declaration. You've already heard most of that from Willie. You've got to read fast around here. What are some of the rights in the Declaration? There's a list. Covers an awful lot of ground. Everything from major rights like self-determination, autonomy, and so on. I list the right to exist as distinct peoples, even though there isn't a separate article about that. I think it's one of the most important things about the Declaration. We had no actual right to exist before the Declaration. Countries could terminate indigenous peoples or simply refuse to recognize that the indigenous peoples were there. Have you finished? Moving on. We'll look at some of these things in particular. Some language that you can read. I think this is one of the most noble of the articles, and it's the one that's most offended by United States law. Because those elements of United States law that I was describing to you, the plenary power doctrine, the business of taking Indian land and all that. I forgot to mention this system of trusteeship, how they just say that, well, most Indian land is held in trust. The United States actually owns it. It's nonsense. They're just making that up. For the most part, it is simply not true at all. They simply made it up, and U.S. law presumes that virtually all Indian and Alaska Native nations are in a state of permanent involuntary trusteeship without serious accountability. No one else is treated that way. Children, but they eventually grow up. They can grow out of it. Insane people are treated that way, but they too can get well. And there's at least some particular condition other than their race or their political affiliation that puts them in that state of permanent involuntary trusteeship. And in all events, everybody else in a state of trusteeship can get the trustee to account for what is being done. Indian nations rarely can get a serious accounting. Rarely. Yeah. Was there a question? I'm sorry.
What was the U.S.'s official reason for voting against that?
They had a number of reasons. The real reason was that the big guys up, and I don't know if they were guys, they may have been women too, but in the State Department, the higher levels of the State Department simply made an across-the-board decision there would be no new human rights commitments, period. I mean, if Moses had come down off the mountain with something, they would not have approved it. And so what happened, the United States government had actually approved of, in open meetings, had actually assented to the majority of provisions in the Declaration. And so they had to kind of scrape around for reasons for objecting to it. I'm going to do this from memory, but the gist of it was they did not like, they were uncomfortable with group rights. They had instructions that they could vote for self-determination, but only if it was called internal self-determination. And since nobody knew what that meant, nobody would go along with that. But anyway, that was another of their concerns. They felt that it was insufficiently clear and would cause a lot of confusion. Oh, isn't that awful? These things, they were pretexts. They came up with a series of 4 points like that were not very serious points, but that's what countries do. They had their little list of reasons, but the real reason was
us to remain wards of the state then.
Well, they didn't say that. No. That would be going too far, but they weren't going to vote yes, even if it had been perfect. And so they came up with the best reasons they could think of on fairly short notice. They didn't like self-determination. They didn't like the fact that rights of groups or communities or nations are being called human rights. Usually human rights are thought of as rights belonging only to individuals, and they don't want to weaken the currency by applying that name, human rights, to rights that are held by peoples or groups or collectivities, collective rights. So they had these kinds of reasons that, yes, they had argued about them in the negotiations, but honestly, we know they were pretexts. The administration now is engaged in a review of that position, and they have said repeatedly and very clearly that they are not bound by those reasons that were given in the United Nations by the U.S. delegation in 2007. They are not bound by that, and that they are reviewing from scratch the United States position about the Declaration. They're in the middle of a review that includes at least 15 federal agencies led by the State Department, but prominently including also the Department of the Interior, Department of Justice, Department of Energy, and so on. They have not indicated what the outcome will be, but the White House level in the administration is very much involved. Kim Teehee and Jody Gillette are very much involved in the review and have been at all the consultation sessions so far. Maybe not all of them, but most of them anyway, at least the ones held in D.C. So there's a very serious review going on, and I'll just now that we're on to this, I should say you can speak up about it. There's something you can do about it. Easy thing to do is just go to our website, and with a couple of clicks of your mouse, you can send an email to the State Department asking them to endorse the UN Declaration on Rights of Indigenous Peoples. And you can add your own comments. You don't have to just do what we've drafted out for you. You can scratch that out and write in your own comments, or add your own comments onto what we wrote. It's an amazingly quick thing to do. 2,000 or 3,000 people have done it already, but it's not enough. And so give it a try. Our website is www.indianlaw.org. Make a contribution to the Indian Law Resource Center while you're at it. We never have enough money because we don't take any kind of government grants or contracts or contributions or anything. We rely only on private money, foundations and Indian governments and so on. So we're always rather poor. But seriously, do it. Even if you don't want to do the click automatic thing, write something yourself. Send them an email. Tell them what you think about the declaration. Now is the time. This is not going to go on forever. They're going to wrap up this review in the next, we don't know, could be a few weeks. They may not wrap it up until early next year, but it's not going to be long. So speak up. They do want to hear from you. I mean, they say that, and I think they're being genuine about it. They want people to speak up. Did you have a question?
Just a quick comment as well. I'm Dr. Richard Grounds on the board with Culture Survival. And one of the projects they're working on is trying to coordinate letters originating from tribal governments, tribal executives to support
Good.
adoption. Contact Culture Survival, cs.org, and alternatively encourage your tribal representatives to.
Yes. There's a consultation at the State Department for Indian and Alaska Native Nations next Thursday, the 14th, 1 o'clock in the afternoon. There was very, very short notice, less than 10 days notice of this. So if you can get people there, by all means do. There's a consultation or a meeting, at least with organizations, the following day, beginning at 9 o'clock at the State Department. That's just next week. So if you can get to Washington and weigh in, fine. There's also a way you can phone in to those meetings. You might want to try that, although it's kind of awkward. Anyway, speak up. Do something. You don't have to just sit here and learn about it. It's a good time to act. This is the self-determination provision from the Declaration. It's a mirror of the self-determination article in the Covenants on Civil and Political Rights and Economic, Social, and Cultural Rights. There's a typo in that, I just noticed. They screwed it up, In the Indigenous Peoples version, they wrote the right to self-determination. We never did that. It was some typist after the working group sessions ended. Somebody just mistyped it and nobody caught it because they rushed it through. It was a little weird. Some things you don't want to know about. But it is important to be aware it makes no difference. And you know how I know that is because I say so. Well, I was there. Several other people in this room were there, and we know that that was never discussed. There was never an issue. The right to self-determination means exactly the same thing as right of self-determination, and that's that. So, I'm serious. Those are rules of interpretation and construction that should be applied. Here's what was written to deal with land rights. It's a little unprepossessing, doesn't look very important, perhaps. By the way, the first sentence, let me tell you the substance of it real quickly. The key thing is that indigenous peoples have the right to own, use, and develop. They have the full bundle of rights about property. That's the trick. No longer can it be said that indigenous peoples don't really own the land, that Aboriginal property isn't really property, or that the Indians don't really own it, so that's why we can take it. Can't say that anymore. That's what that article is really about. Yes.
I apologize for interrupting.
That's right.
Curious to this statement of land. The absentee Shawnee and the Potawatomi are struggling amongst themselves over land. I'm a little concerned and confused by this. Do you have any insight on that? I mean, not only are we fighting the government for land, but we're fighting each other.
Yeah, that happens all the time. And while it's a difficult and awful thing, don't feel special. Well, sometimes we're made to feel bad. We're fighting among ourselves.
No, it's
it's
not
like we're
just
awful. Well, everybody fights among themselves. So moving on from there, one of the problems on the very last day of the very last working group session, somebody proposed that first sentence. It was never discussed. Nobody even knows what it means. Then the chair of the working group, on his own, simply inserted it into the article. It was, as I say, never debated, never discussed. It's very hard to figure out what it means, but I can help you this way. Chair of the working group is a Spanish speaker. His English is excellent, but he's a native Spanish speaker. The Spanish version of that text doesn't have an article before the word right. It's simply derecho. Now, the correct interpretation of the Spanish text of that first sentence should read, indigenous peoples have a right to the lands, territories, and so on. It isn't something we would normally say in English. That's not actually very good English usage. It's okay in Spanish, but it doesn't translate very well. In this case, they put in the definite article the, which sounds in English, that seems to say that an Indian nation actually owns all the land that it ever traditionally owned, occupied, or otherwise used. Well, that would mean for our Potawatomi nation that we still own all the land in Michigan and Wisconsin and Kansas and everywhere. Well, that doesn't make any sense because a lot of that was given up in treaties that have long since been accepted. It's not under dispute. But that's what gives rise, and I really am answering your question. What happens with that is that you get various Indian nations with claims or asserted rights anyway to the same land because the government was always crowding people together and making overlapping reservations and creating various kinds of land rights that put one nation in conflict with another. And it does make a very difficult situation, especially if this is really true that indigenous peoples really own all the lands they ever really owned. But it doesn't actually mean that. And I think that the chair of the working group, I know, the chair of the working group wrote a little piece, I will get to you, wrote a little piece explaining this sentence. He said this is supposed to be an overarching statement. Meaning, I guess if it could be written well in English, it might say, indigenous peoples have rights to the lands that they have traditionally owned, occupied, and so on. But what are those rights? That's what the rest of the article explains. What are those rights? And there are a few articles in addition to this one that also explain. This article says, well, they have all these rights to land that they now possess. But they also have rights to make claims for redress or to recover or get compensation for lands that have been wrongfully taken. They have rights to get their lands demarcated, that is, specially lined out, so that they're not indefinite. There are a lot of different rights that indigenous peoples have with respect to their lands, and those rights are made specific in other articles. And this was just meant to be an introductory sentence, the chair of the working group says. And that's consistent with our finding that it's actually, in English, a mistranslation of the Spanish text. You didn't need to know all that, but well, perhaps you do, because it is sort of a centerpiece of the Declaration, and will give you some idea of what it was like trying to get this stuff through the United Nations in a workable way. You had a question.
Yes, I do have a question concerning, I know this article deals with land. I'm curious to see if, are there any articles that pertain to water, sacred or otherwise?
Not specifically, but water is included in a kind of definition of lands. I believe it's the previous Article 25, has a kind of a laundry list. Well, it's lands, waters, sea ice, Everything we could think of was thrown in there as being included within these rights. Sometimes the term territory was used in an effort to have a comprehensive term that would include water and ice and offshore stuff and all the other things. So water is covered. In this, it's really covered for the most part by the term resources. Let's see if we can move on. You saw that about treaties. Don't need to look at that anymore. Let me, I don't mean to be silly or overly brusque, but it wouldn't hurt anything if I looked at my notes every now and again. The thing is, what can you do now that we've got the Declaration? And if it's true that we went to the United Nations in order to get a toehold, get some kind of grip on things so that we could begin to reform what's wrong with United States law, well, what are we going to do about United States law? Well, I don't know what we're going to do about United States law. I don't know everything. But I could figure out some stuff. Actually, you know the way it works, you get this stuff through the United Nations. I spent fully 30 years working on the Declaration. And like so often happens, in the end, I was disappointed. I was really browned off. I thought it should have been way better than it was. I thought we should have gotten the U.S. and these other countries to sign on and so on. And I was exceedingly disappointed that it was so messy. But I, went back into my mountain fastness in Montana and started writing down what I thought United States law should be. If I don't like what it is, well, you can't go on just griping about it. You better be ready to say, well, what should it be? Or if the courts are getting it wrong, how have they got it wrong, and how should they be deciding cases? And I thought if we could write those things down and work with Indian and Alaska Native nations around the country to see what people wanted, see what people think is sensible, see if we can build up a consensus about, well, how should the law be changed? That maybe we would be in a position to begin a campaign. When I say we, I mean it's going to have to be Indian and Alaska Native leaders to do a campaign to change the law. But in order to make it work, we'd better know, and we'd better have some kind of agreement or common shared vision of what would the law be. Well, we wrote down a total of 17 of these principles. Some of them are already the law, and the principle is really nothing more than a clarification of what the law already is. My point today is that these principles, you can see, grow right out of the Declaration. They also grow right out of our United States Constitution. They grow out of the treaties. These principles, the idea, by the way, is that these principles, these proposals for changing the law, they must be based on the United States Constitution. They have to be consistent with it, because, I mean, what's the point if they're not ever going to be law in the U.S., are they? They have to be consistent with the treaties made with Indian nations. They have to be consistent with international human rights law, and they have to be consistent with general principles of fairness and justice. Those are the criteria. And I think those are perfectly sound American values. This isn't something that Indian people cooked up to get over on the U.S. or something. This is something that anybody could live with, in my opinion. Well, look at that one. That's the land rights bit. That is designed to overcome that Tehitan Indians case that says, every schoolboy knows that the Indians don't really own their land and we can take it from them anytime we want. This is, in my opinion, what the law of the United States actually is, based upon our Constitution and the basic principles of American law. That actually is the law right now. It's just the courts don't decide cases that way. By the way, what you see there is the actual legal text of the principles, followed by a plain language version. I'm going to have to speed up here. Let me show you some of these. This one I love. There's so much stuff said about discovery. Turns out, well, this principle essentially says that the so-called law of discovery or doctrine of discovery didn't give the discovering nations any rights as against the Indian nations. Well, if you read Worcester v. Georgia, you know that that's been United States law since 1832. But many people go around the country, including government officials, go about with this idea in their head that discovery by a European country gave the discovering country all the right to that native land. That never was the law. International law never provided that. Not only was it never the law as part of international law, it's never been the law of the United States. As far as I know, there's not a foot of ground in the United States of native land that's been claimed by the United States government by right of discovery. You can go down to, I'm sure you can ask people in the Department of Interior today about the doctrine of discovery, and they'll say, oh yeah, we have trust title to this land. We own the land by right of discovery. They're wrong. That is not the case. That is simply false. It never was true. But everyone from high government officials to the federal courts behave as if it were true. This is the law. Discovery did not do that, and the Supreme Court even today affirms that this is true. I mean, after all, if we lost all our land by reason of discovery, why do we have land today? I mean, it obviously isn't true. I don't know why people keep believing that stuff, but they do. This is sort of saying the same thing. There's a lot of racist stuff about terra nullius and all this that's used to diminish land rights. We're going to have to wrap up, aren't we? Lindsay?
No, I just have a quick question.
Sure.
Are there any books you'd recommend people read to get this point?
Oh, Lindsay's got a good book. You know, honestly, it isn't written up very well. Well, your book is singular in that respect. What's the exact title of it?
Conquest by Law.
Yeah, a really fun book to read. The best thing to read, though, if you want to read something, is go to Oppenheim's International Law and read what they say about acquisition of title by discovery. They mostly rely on the World Court, you know, the International Court of Justice decision in the Western Sahara case. Makes it perfectly clear that it's not just in the United States, but worldwide, doctrine of discovery did not give ownership of land to the discovering country. Simply isn't true. Anyway, let's see what else we can look at here. Oh, how did I get going backwards? Sorry. You know, one thing full constitutional rights for Indian nations. I don't see any reason why Indian nations should be deprived of constitutional rights that everyone else enjoys. That does not mean Indian nations give up any of their distinct or unique rights as Indian nations, but they certainly shouldn't be treated in a discriminatory manner. Here's the one that would say you just can't go out and take Indian land without paying for it. You at least have to comply with the Fifth Amendment. This is the one that might be the most startling. The United States has trust title to Indian land, but only if the United States has acquired that title through a valid legal process. That sounds like a very ordinary statement, but what we found is that the great majority, and I mean tens of millions of acres of Indian land that is said to be held in trust by the United States, is not. There never has been any valid legal process, nothing at all. There's absolutely no legal basis for the United States claim of trust title. And I mean nothing whatever. There's not a court decision, there's not a statute, there's not a treaty, nothing whatever. Somewhat startling because everyone in the federal government believes that most Indian land is held in trust. It simply isn't true. There is a lot of Indian land held in trust because Indian nations have asked that it be held in trust. They've actually officially turned it over to the United States government asking that it be put in trust. And sometimes the federal government owns land, free and clear, legitimately, and turns it over to an Indian nation in trust. That's perfectly fine. There's no problem with that. That really is trust title land. But most Indian land, and this applies particularly in the large areas in the plains and in the Southwest where huge treaties were made, that land was owned outright by the Indian nations involved. The treaties make no provision whatever for trust title, and nothing was ever done to put any of that land in trust. It isn't in trust. That's the law. And screwing things up by pretending that certain legal facts exist when they don't causes enormous trouble. If Indian nations want to hold their land in trust, they can certainly get it done, but the law now subjects Indian nations to trusteeship without any legal basis, and that's always a problem. Some of the other principles deal with, there's no time to show you all of them, they deal with what are the obligations of the federal government where it does hold land in trust. I mean, it needs to account for it, it needs to protect it, and so on. There's a provision saying no termination. There's a provision saying Congress doesn't have plenary power, it only has the powers enumerated in the Constitution. Duh. I mean, that's been the law of the United States for nearly 200 years, but it hasn't been applied to Indians. There's a provision saying that there needs to be, and there is a right to judicial remedies, because the remedies available in court to Indian nations are too limited. They're not adequate to correct wrongs. There's a provision saying that the United States must abide by international human rights law, and so on. What's going to happen with this? Well, we've gotten a very, very strong positive response from many Indian governments around the United States, and they are, some of them anyway, planning on getting together to make some kind of strategy for initiating a campaign to try to implement or get some of this reform done. What they will decide to do, I don't know. No one knows at this point. But in the meantime, we're going to be trying to provide this information to everyone, judges, law students, government officials, and so on. It is available, but it's never been published. I can email it to you. It's available on CD, and we could print you out a hard copy. There are the principles and then commentaries. Altogether, it's, I don't know, 300 or 400 pages of work. I commend it to your attention. I hope you will take an interest in it, because I think we need to do things that are positive, affirmative, and will make changes that we much need. Some people feel it's important to do things to implement the Declaration. Well, yeah, it is implementing the Declaration. I just think we should do it. I don't care what you call it. We need to make these changes. Well, I'm sorry for yakking on so long. Questions? No. Done. Thank you so much.